Yeah, thank you very much. The first thing I'm going to do is going to read the amendments into the record, and then I'm going to deal with them in sequence. The first amendment, Amendment 4, is in page 8 between lines 2 and 3 to insert the following. 2. Section 27 of the Act of 2015 is amended by the insertion of the following new subsection after subsection 5. 6. When a child is conceived through non-clinical donor-assisted human reproduction procedures should be in place to recognise a second intended parent as a legal parent. Really what I'm doing in these amendments is making up deficiencies, gaps, lacunae in the legislation. Amendment number 5 is in page 8 between lines 3 and 3. That's wrong, must be 2 and 3. To insert the following. Section 27 of the Act of 2015 is amended by the insertion of the following new subsection after subsection 5. Retrospective applications for a declaration of parentage in cases of donor-assisted human reproduction should be recognised where a known donor was used. I mean, it's an extraordinary exclusion that the known donor is actually excluded. I don't understand the logic behind that at all. Number 6 is in page 8, line 3, to delete and substitute the following, delete the inverted commas. Section 27 of the Act of 2015 is amended by the insertion of the following new subsection after subsection 5. 6. The second intended parent in cases where she provides her egg to enable conception should be recognised as a legal parent. And number 7, finally, in page 8 between lines 3 and 3, I don't understand that, insert the following. Section 27 of the Act of 2015 is amended by the insertion of the following new subsection after subsection 5. 6. When a child is conceived through surrogacy outside the state, procedures should be in place to legally recognise the parents of the child conceived. And I've received quite a number of messages from people, emails and so on, people who conceived the child in Canada or Great Britain or wherever it was, and it's not recognised. So although the bill is very welcome and it is an improvement, there's no question that there are certain issues that are not addressed properly in the bill at all. For example, options for lesbian and gay families who perform at home insemination. They're not contemplated at all. When they have a known sperm donor, and this is the case to which I referred already, and they avail of fertility treatment outside of Ireland. Now, I have a letter from a male same-sex couple. They say the current AHR bill, as it stands, more specifically Part 6, is not fit for purpose, as it will exclude all surrogacy families that have gone through surrogacy journeys abroad and all future families that choose to go abroad. Another letter, another email. Somebody says, as a same-sex male couple who have created a family through the process of surrogacy in Canada, there is no legislation currently in place due to be enacted or currently being drafted that include my family and many families like ours to recognise my husband and I as the legal parents to our son. For our family to be recognised, we need the general scheme of the Assisted Human Reproduction Bill 2017 to include same-sex male families who have used international surrogacy as a way to create their families. Now, this is a glaring omission in the bill, and I'd like to see it rectified. And now, from a female gay family, my wife and I live in Dublin 7, are a married same-sex couple with one daughter, Catherine, who is 6 months old. Currently, I am, as the birth mother of our daughter, considered a single parent, and my wife has no legal connection to our daughter. Our daughter is classified as having a single parent and has no rights to one of her mothers. Our only option at the moment is to wait 2 years and apply for guardianship, which expires at the age of 18 anyway, so it's gone at that point, and does not give full parental rights. Once the Children and Family Relations Act 2015 is fully commenced, perhaps in 2019, we may also have the option of applying for step adoption after 2 years, but this can take up to 7 years. You know, there's an enormous gap there in the process, and I just don't think that's acceptable. As a matter of principle, and that governs the 4 amendments that I've put down, it's argued and recognized internationally that the principle that underlines all these items of legislation should be the best interest of the child. You know, it's not the behavior of the parents. It's not where the child was conceived. The child has no control over that. And why should an innocent child be victimized for something over which they have no control? So the first thing I'd say is the best interest of the child are paramount here in this situation. And I'd like to look at a number of the cases. First of all, there's a question of known donor outside a clinical setting. In other words, where it's a non-clinical intervention, either by, I'll put a case on the record where this actually has occurred. Non-clinical procedures are currently excluded from the parentage provisions in the Act. The result is that children conceived through DAHR outside the clinical setting do not have a legal relationship with the second intending parent at birth. Children conceived through DAHR outside of the clinical setting are therefore disadvantaged when compared to children conceived through DAHR in a clinic by virtue of the circumstance of the conception. Again, this is greatly unfair to the child involved. The case study that I put on the record is as follows. Because I do think that for the purposes of informing the public, as far as there are any public watching this at the moment, I think it's important to put a human face on the situation, and nothing does that better than case studies. Elaine, the birth mother, and Jenny conceived their baby girl at home using sperm donated by Jenny's brother, so there's no need for a clinical intervention at all. They had no problem conceiving and did not need any clinical intervention. Their donor is happy to give consent to both women being recognised as legal parents, so there's no objection from the sperm donor. As their baby is only 3 months old, Jenny is unable to seek guardianship under the CFR Act 2015 as the child is less than 2 years old. Therefore, as the law currently stands, she has no legal relationship to her child and is unable to establish a legal relationship until her daughter is 2 years old. So there's a very considerable gap there, and I think that needs to be addressed. Now, if we look at other jurisdictions, we can learn something from them. Because other jurisdictions have addressed this issue by extending a statutory presumption of marriage to some couples. In the United Kingdom, for example, a statutory presumption of parentage operates in favour of same-sex married couples and civil partners, but not cohabiting couples in cases of donor insemination. As such, the spouse or civil partner of the birth mother is automatically regarded as the child's second legal parent, regardless of whether the procedure takes place in a clinical or in a non-clinical setting. In British Columbia, a person who is married to or in a marriage-like relationship with the child's birth mother at the time when the child is conceived is deemed to be the child's parent unless it is shown that he or she did not consent to be recognised as such. So here are two other jurisdictions in which the matter is addressed clearly and the rights of both parents are established. Now, then there's a question of known donor in a clinical setting. I fail to understand why the fact that the identity of the donor is known should restrict the rights of the child. I just don't think that's fair. For children who are conceived prior to the commencement of Parts 2 and 3 of the CFR Act, parentage may be retrospectively allocated to an intended parent not previously recognised as a legal parent through application for a declaration of parentage under Section 21 or 22 of the Act. In order for the declaration to be granted, the donor must have been and remain unknown to the intending parents at the time of the application. Now, I'd be interested in, if the Minister is supporting the existing situation, if she give an indication of reasons why it's important to remove a known donor. And again, I have a case study. Jane, the birth mother, and Sarah have an 18-month baby boy, Jake. Jake was conceived in a fertility clinic using sperm provided by an identifiable donor. Jane and Sarah want Jake to know about his origins, so they have obtained identifying information about the donor. And I think that's also important for medical reasons. You know, one of my correspondents has a child with a genetic disorder, and I think it's very important for them to actually understand and know. So there's a good reason for knowing the donor, or knowing about the donor at least, because you'll have significant medical information available for that reason. So they can educate Jake about his genetic background in an age-appropriate manner as he grows up. The women have never met the donor but know his name and last known address. Jane is the birth mother of Jake and is recognised as the legal mother. After Parts 2 and 3 of the CFR Act are commenced, Sarah will be unable to obtain a declaration of parentage listing her as the second legal parent simply because a known donor was used. Don't understand it. Don't understand it at all. And then there's the question of fertility treatment which is received abroad. I mean, I've had correspondence with people who've had this procedure done in Canada and also in the United Kingdom. Section 20 of the CFR Act provides that application for a retrospective declaration of parentage may be made in respect of a child conceived before Parts 2 and 3 of the Act are commenced, who is conceived by DAHR, performed in the state or outside the state. For children born after Parts 2 and 3 are commenced, the procedure must be performed in the state. Okay, don't understand that. I mean, the procedures have quite an ancestry in places like the United Kingdom and Canada, and so why they shouldn't be recognized, I simply don't know. I give the case study again. Sue and Teresa initially attended Dublin Clinic for AHR treatment, but when significant fertility issues were identified, they had to look abroad for further treatment options. In other words, they didn't have a choice. If they wanted to have a child at all, they had to look elsewhere, outside the country of their residence. Their daughter was born in early 2018. As she was born before the CFR Act commences, Teresa will be able to apply for a retrospective declaration of parentage, naming her as a legal parent. However, the couple, this is a significant point, the couple have a number of embryos in storage. So they're a possibility that's not been entertained or acted upon so far. If the couple uses embryos in order to conceive a genetic sibling for their daughter, they will not be able to apply for parentage under the CFR Act. And this, again, is something that needs attention. So, under the Assisted Human Reproduction Bill, only domestic surrogacy is permitted once the legislation is enacted. And I think this is very restrictive. There's no provision in place to recognise the parentage of children who were or are born through surrogacy before the bill is enacted and commenced. The child has no control over the circumstances of conception and should not be disadvantaged by the virtue of the fact that he or she was conceived by surrogacy or abortion. Again, I return to the principle of the best interests of the child. And the child has no responsibility in the activities of the parents. So it's not culpable and should not be discriminated against as a result of this. It is argued that it is in the best interest of the child for his or her relationship with the intended parents to be legally recognised. And this has been recognised with the United Kingdom courts. And I have a quotation from a judgment. This is the judgment of one of the United Kingdom courts in this matter. It is almost impossible to imagine a set of circumstances in which, by the time the case comes to court, the welfare of any child, particularly a foreign child, would not be gravely compromised, at the very least, by refusal to make an order transferring parentage to the intended parents. This is a senior judge in Britain saying that the welfare of any child would be gravely compromised at the very least. I mean, that's a very significant point to be made. So with these remarks, I would hope that I might have persuaded the Minister on some of the amendments at least. Thank you very much.